Thank you, Mr. Chairman. I'm very grateful to the North Carolina Commission of Inquiry on Torture for the opportunity to share with you some thoughts. And of course, I commend you on the initiative to do this hearing and conduct this inquiry. I've been asked to talk about global perspectives on U.S. torture and lack of accountability, and I will focus mostly on my experience as the former United Nations Special Rapporteur on Torture, a position that I occupied between 2010 and 2016. But I think it's important to look at global perspectives on a broader scale than my experience in that job. And particularly, I want to point out, among many other important landmarks of global perspectives on U.S. torture, a few decisions and reports that have been done over the years. In particular, I think the United Nations Committee Against Torture, which is the implementing organ of the United Nations Convention Against Torture that has been mentioned here already, and must be stressed that the United States is a party to the United Nations Convention Against Torture. And although the United States has not accepted the possibility of the Committee Against Torture entertaining individual complaints, nevertheless, the U.S. is bound every 5 years to come before the committee and to explain what it's doing to prevent and to punish the crime of torture under its jurisdiction. And the committee has probed very deeply on the matters that are before us today and has made very strong findings about U.S. responsibilities under the Convention Against Torture in the context of the global war on torture, in the context of Guantanamo and the secrecy and lack of access to Guantanamo Bay prison and so on. That's one important international aspect. I would also mention the Inter-American Commission on Human Rights of the Organization of American States, because although unbeknownst to many people in the United States, the Inter-American Commission does have jurisdiction to entertain cases and situations affecting the United States, because the United States is a member of the OAS and as such is subject to these kinds of inquiry. The Inter-American Commission has repeatedly engaged the United States government on issues regarding torture and particularly on Guantanamo. And I say repeatedly because it has several reports, very well researched, by the way, that I really commend to you. The most recent one, in fact, it's called Closing Guantanamo, and it brings the U.S. government to task for having failed, after all these many years, to close down a prison that is a symbol of torture. In addition to those two, I should mention also that the European Court on Human Rights has now issued more than, I think, 2 or 3 decisions against Poland, against Albania, precisely on some of the issues that Professor Raphael was talking about. And in those decisions, in no uncertain terms, the European Court of Human Rights has mentioned the United States, the CIA, by name, not, of course, not as a defendant, because the European Court doesn't have jurisdiction over the United States, but it has really embarrassed, the actions of the United States have really embarrassed long-term allies of the United States that are subject to the jurisdiction of the European Court of Human Rights. And finally, I think we should also mention domestic courts investigations that have happened in many different countries, including allies of the United States, that have revealed the implication of the respective country in complicity with the CIA and others, including just to name one, the Italian case that I think is going to be the subject of some debate later here today, but also in the United Kingdom, the Belhaj case that involves rendition to Gaddafi's Libya by the CIA, the United Kingdom, and Thailand. Those are the larger picture of what needs to be discussed when we talk about global perspectives on U.S. torture and lack of accountability. From my experience, I should say that from the very beginning of my term, November of 2010, I engaged in discussions with the U.S. government about several different cases. Just to name a few that will be familiar to you, I wrote my views after engaging in discussions with the United States government on the Bradley Manning case, now Chelsea Manning, precisely because it was about solitary confinement before any definition of guilt or innocence, and where the accusation was revealing incidents of torture that the United States had engaged in. As you know, he was later moved to another prison where he was no longer in solitary confinement, and fortunately, President Obama eventually pardoned her. But I do remember a case. I remember vividly talking to the father of a young man who was extradited from the United Kingdom. While he was awaiting extradition in the United Kingdom, he had been treated quite well. But the moment he was brought to the United States, he was held first in the Manhattan Correction Center and later in ADX in Florence, Colorado, and he was subjected to solitary confinement. And the father spoke very movingly about the effects that this was having on him. He was held for years, literally 3 or 4 years in solitary confinement until he plea bargained. And then he was convicted to something like 20 years for the crime of lending his computer to a friend who apparently, that apparently becomes material support for terrorism. But what was really striking was that after the sentence, he was then sent to ADX and held in what they call special administrative measures, SAMs, but amounts to solitary confinement for the rest of the term that he's serving. I also had occasion to work on the hunger strike in Guantanamo, and particularly to object to force feeding. My rapporteurship did the same with an almost contemporary situation of hunger strike in California prisons, not related to counterterrorism, but very similar in the sense that federal and California prisons used force feeding to counter the hunger strike. I should mention also that my predecessor and other mandate holders had, before my time, commissioned with the help of the Office of the High Commissioner for Human Rights, a detailed study on detention, it's called, and it was published, I think, in 2009 or 2010, right before my time. And my other mandate holders and myself, we tried to do a follow-up and send questionnaires to many countries that had been named as participating in the secret detention policies to find out what had been done to correct and remedy the problems that had been identified. Unfortunately, the follow-up was a complete failure. No country wanted to assist us on this, and some countries very actively told us that we didn't have a mandate to do that. And eventually, I think the Office of the High Commissioner run out of reasons or funding even to conduct a follow-up report. But I think the original report stands as an important document of the United Nations dealing with secret extraordinary renditions. And so because of this, I also, I should mention that I wrote my views on the use by the Obama administration of the state secret defense in the Jefferson data plan case that Professor Rayfield looked at. As you probably know, that defense was successful. The court basically declined jurisdiction only because supposedly proceeding with a case involving torture would have put in jeopardy the methods and sources of intelligence by the United States. So those are some of the examples of things that I did during my tenure. But as you know, you probably know, special procedures act basically on three methodologies. One is individual cases. The other one is country visits. We seek invitations and then write reports on comprehensive reports on country situations. And the third is thematic reports. Those examples that I've mentioned are of the first kind, the individual cases. But I did, from the start, try to be invited to visit Guantanamo Bay. In my predecessor and three other mandates had sought, back in 2004, an invitation to visit Guantanamo Bay, and the Bush administration did invite them. But they invited them with terms of reference that they could not accept. We have to ask for the same terms of reference that we request from every state, and we cannot, as you can imagine, provide an exception for Guantanamo, because then otherwise all states would demand the same exception. So when I first talked to the Department of Defense and the Department of State, I asked them, look, don't give me the same terms of reference that you gave my predecessors 6 years ago, because I'm going to have to decline as well. By 2012, I did get an invitation to visit Guantanamo Bay, but the terms of reference were one, that I was going to get a briefing by the administrators of the prison, that they were going to show me some parts of the prison, but not all. And the more important one was that I was under no circumstance going to be able to talk to any inmate in Guantanamo Bay, even under conditions of surveillance or supervision or whatever. As you can imagine, I had to decline. I declined, but I insisted on different terms. But unfortunately, from 2012 to now, because I know my successor has not yet, at least, received a new invitation, that's where it stands. The Pentagon insists that those are the same terms that they give U.S. legislators and journalists. And we say that that's not enough. That's not good enough. We have to be able to see every part of a detention facility. We have to be able to talk to prisoners of our own choice, and on conditions that they're not under surveillance, that they can speak freely to us. Unfortunately, that has not happened. Later on, I asked to visit prisons in the mainland, particularly to look at solitary confinement. That is a particular concern of mine, involving also a thematic report that I wrote early on. And I participated as expert witness in litigation in the United States concerning solitary confinement. I was particularly interested in visiting several state prisons, but also federal prisons. And these discussions lasted literally all these years, from 2011 to about 2016. And the State Department would ask me, well, which states? And then when I mentioned 6 or 7 states, they would ask me, well, which prisons in those states? And I would say all of them, but maybe, okay, just for practical purposes, I would identify 2 or 3 prisons in each state, and then I would ask specifically to go to federal facilities. The end result is that no state accepted the invitation, or agreed to invite me, and with the Federal Bureau of Prisons, finally they said that I could visit ADX, and I could visit every part and talk to anybody I wished. except for inmates accused or convicted of terrorism. So as you can see, I also had to decline that. Let me mention the torture memos that have been mentioned here before. And of course, it's completely out of the scope of this hearing to do a legal critique of it. But I want to mention 3 or 4 outrageous statements that are made there. One is that this doctrine of the powers of the President of the United States as Commander-in-Chief of the Armed Forces to conduct war without scrutiny by either any other branch of government. It almost states, I think, almost in those words, that the President of the United States is not restricted by law on any method and, that he wishes to use. The second is the definitions of torture and cruel, inhuman, and degrading treatment that have been read by Professor Kirk, and I think the language is very clear. The torture memos play with the words about severity to make it look like something is cruel, inhuman, and degrading treatment, but not torture, with very clearly not saying that cruel, inhuman, and degrading treatment is still absolutely forbidden. No agent of the United States, or of any country for that matter, can engage in cruel and inhuman or degrading treatment. But in addition, to raise the level of severity of torture to organ failure or death is really outrageous. I mean, it's almost to say that if you are tortured close to death but you don't die, then it's not torture. And then finally, the illegality of cruel, inhuman, and degrading treatment. As you know, the torture memos are about advising CIA agents about whether they would be prosecuted if they did a number of things. The fact that they might not be prosecuted would not render what they did legal, and the torture memos don't say so. I know I have little time, so I just want to say that there's been evolution of policy after 2009, that the executive order of President Obama seems to have had very good effects. I say seems because this is so much surrounded by secrecy that I would not stake my reputation that no torture has happened after 2009. But we have to be honest and say that the information that we got until 2009 and what has happened after 2009 seems to me to be very, very different. And we also have an act of Congress now propitiated by Senator McClain that prohibits torture under all circumstances and reinstates the Code of Military Justice on this matter. Unfortunately, the attempts to close Guantanamo have failed, but it's also true that the numbers did dwindle, and towards the end of his tenure, President Obama continued to try to close down Guantanamo. What has to be lamented is the excessive rigidity of conditions under which people will be released who have been declared as being of no interest to the United States and therefore have been cleared, quote unquote, for release. The fact that of the 41, I think, people still remaining there, many have been there for many years without ever having been, and with many of those years after being cleared, means that the United States is engaging in prolonged arbitrary detention. Prolonged arbitrary detention under international law is a very serious offense. It's a very serious violation of obligations. In fact, the United Nations Committee Against Torture has recently said that prolonged arbitrary detention could itself be considered torture. I do want to mention truth-telling because the United States has at least partially fulfilled one important obligation under international law. I mean, of course, the Senate Select Committee on Intelligence report, but also previously the Senate Armed Services report in 2009 that did an excellent job of investigating, under Senator Levin, investigating and disclosing what could be known about what the Defense Department services had conducted. It deliberately stayed away from the CIA because of jurisdictional reasons and because the Senate Committee on Intelligence supposedly was working on it. We had to wait several years for that committee report to be released, and it's painful to say that it was released only by the decision of the committee itself, not by the decision of the executive branch. And as we know, what we have is only the executive summary and very heavily redacted at that. Nevertheless, it is an important measure of truth-telling around what the United States did. I also think that, as we said at the time, that this is only partial fulfillment of the obligations of the United States. Under international law, even a single act of torture elicits from the state an obligation to investigate, prosecute, and punish the perpetrators, whoever they may be. So telling the truth is part of that, but the next step, the investigation and prosecution, is not happening. Also, the truth-telling is, of course, partial for the reasons we've already said. It's important to have access to the full report, at least for academics to have access to the full report. And the other thing that I would say is that the report seems to, it does a very good job of debunking the myth that torture works. It establishes very clearly that most of the good intelligence that the United States obtained was not obtained through torture. But I think it's regrettable that, at least in the public domain, the debate has been about whether torture works or not, kind of minimizing the moral and legal aspects of whether torture can be performed or not. Nevertheless, of course, it's an important part of the debate to show that torture not only doesn't work, but that it creates, it has a very heavy political cost, a cost in reputation, cost in confidence, in trust on institutions, and particularly cost in relations with the international community and particularly with US allies around the world. And finally, the decision not to prosecute. As I understand it, it's based mostly on the Special Prosecutor Durham's report after investigating the torture memos mostly, that basically, even though the torture memos had been withdrawn, and they were withdrawn after they were leaked, not before, but they were withdrawn because they were wrong on the law and immoral and illegal under all other circumstances. Nevertheless, Prosecutor Durham allowed them to become a sort of defense for people who might have committed the torture. And it was a categorical defense. I mean, there was no prosecution, not only of of individuals that might have acted under the 5 techniques, but who might have exceeded them. In effect, this decision not to prosecute, supposedly because people were presumed to have acted under a mistake, an error about the legality of what they were doing, has resulted in lack of investigation of any of these acts. And so it's a blanket refusal to prosecute, which in my mind is very similar to a blanket amnesty for torture. And blanket amnesties for torture are illegal under international law, are illegal under US constitutional law, and in fact are immoral for a variety of reasons as well. So unfortunately, the United States, from an international law perspective, is clearly in violation of its obligations under the United Nations Convention Against Torture. So I just want to finish by restating what those obligations are. And it's first to investigate, prosecute, and punish each act of torture that has been not only long-standing international law, but respected and applied by the United States to other countries all the time, and especially with the country reports on human rights practices that the State Department publishes annually. The second obligation is to reveal and disclose the torture that actually did happen, the truth-telling aspect. The third is to offer remedies and reparations to those who have been tortured. In this case, especially at the military commissions, there's a stumbling block. I mean, the military commissions don't know how to proceed to deal with the allegations and perhaps evidence of torture that some of the people subjected to them have happened without also disclosing what happened, and is stuck with even with ethical problems for the lawyers who defend them because they cannot proceed to defend them ethically, while at the same time cannot reveal even to the clients what they know about what happened. And finally, the United States has to devise measures of non-repetition. And I think this hearing and the esteemed members, commissioners of the North Carolina Commission of Inquiry could do a great service to the country if you were to come up with some ideas about what long-term institutional reform is needed so that this doesn't happen again. Thank you very much.
Commissioner.
All right, we will now take questions from the commissioners. Go ahead.
Hi, thank you. Can y'all hear me? Thank you for your talk. The question I have,
A little louder.
sorry, I can't reach it. The question I have pertains to the European Court of Appeals decisions against Poland and Albania. Could you discuss that in a little detail, especially as relates to any reparations that might have been made to victims? Thank you.
I will have to answer from memory, and memory is not very good lately. But in the case of Poland, I think the evidence points to the fact that the detainee could identify a bottle of mineral water, of all things, as being from Poland, and that eventually led to it. The European Court found against Poland, and Poland has defended itself very aggressively and has lately refused to accept some of the remedies that the European Court has established. But quite frankly, with the subject not being now under the jurisdiction of Poland, there's not that much that could be done except offer reparations and perhaps being a little more forthcoming about what Poland knows about what happened. Beyond that, I don't know. Sometimes the European Court doesn't offer reparations. They basically say that their decision is itself a form of reparation. In this case, I don't remember whether they requested or demanded reparations. I'd have to look it up. I'm sorry.
Commissioner Kirk?
Thank you. I wonder, you have a very, very unique position in your knowledge of this issue of torture. And I wonder if Commissioner Crane asked the question, how did the United States learn this? Like, how do these techniques and how does this body of knowledge come to be deployed in this way? And you have long experience both from Argentina and as the special rapporteur and elsewhere. How does a country learn this?
Well, I mean, that has been studied extensively. I think Professor Raphael answered very accurately about some of the ways in which the U.S. intelligence agencies learned and sometimes assisted or participated in torture abroad. That's a history that cannot be ignored. But I am not one of those who say that only the United States was responsible for the torture in Latin America. I mean, in my experience, Latin American torturers learned the trade very quickly by themselves. There is, of course, an element of complicity because what happened in the dictatorships in Latin America, and unfortunately happened and still happens under democracy in many countries, is not unknown to U.S. Diplomatic and intelligence connections that they have there. But I think, especially in Latin America, that torture was much less sophisticated, if that's a name for it. And so it's not that hard to learn how to beat up a prisoner or to apply electricity or waterboarding, etc. There's nothing particularly technical about it. I think, in fact, what we should focus on is that the definition of torture is, the center of the definition is the pain inflicted deliberately. And it can be physical or mental. That's a definition in the convention. The pain that is inflicted, for example, through stress positions, through sleep deprivation, through sensory deprivation or overload, those things are, there are others who can talk more about that than I can. But I think people lose sight of the fact that psychological or mental pain can be and sometimes is much more devastating than physical pain. And again, if the question is how did the United States learn about it? Well, there's a long history of at least intelligence complicity, if not direct participation around the world.
Commissioner Crane?
I do have some questions, but I think we're running into time issues, so I'll defer.
Okay. Well, thank you very much, Mr. Mendez. We are going to take a 20-minute break. We will start precisely here at 11:20. There are some questions from the audience that we don't have time for at this moment, but there will be an opportunity for members of the public and witnesses and commission members to talk after the close of the hearings this afternoon, and you will hopefully have an opportunity to answer to ask your questions then. So thank you, and we'll see you back here at 11:20.